Good morning, good afternoon, or good evening, depending on where you are, and welcome to this lecture of the STARS webinar series on democratic constitution making between deliberative and crowdsourced forms of constitutionalism. Today, we will look at a different dimension of the issue, specifically the territorial one, and we will do so with a lecture by Professor Francesco Palermo on proceduralizing territorial conflicts in the name of constitutionalism. Let me say that it is truly a great honor to have Francesco Palermo with us today. And so thank you very much, Francesco, also on behalf of Giuseppe Martinico. Maybe a few words to introduce our guest. Francesco Palermo is full professor of comparative public law at the University of Verona and director of the Institute for Comparative Federalism at Eurac Research in Bolzano, Bozen. He is president of the International Association of Centers for Federal Studies, constitutional advisor to the Congress of Local and Regional Authorities of the Council of Europe, member and vice president of the Scientific Committee of the European Union Agency for Fundamental Rights, and previously he was senior legal advisor to the OCSI High Commissioner on National Minorities and President of the Advisory Committee under the Council of Europe's Framework Convention for the Protection of National Minorities. He has published extensively on the topics of federalism, European public law, territorial conflicts, and minority rights. But among his many publications and books, let me mention a very important book for me and for all those interested in federal studies, a book written with Karl Kostler and published by Art Publishing, Comparative Federalism, Constitutional Arrangements and Case Law. I think I have stolen enough time from Francesco Palermo's lecture. And so, Francesco, the floor is yours, and thank you again for having accepted our invitation.
Thank you, Matteo. Thank you, Giuseppe, for the invitation. It's always a pleasure to do things together with you, and great colleagues are always a great benefit, actually. So it's actually really an honor. When I accepted the invitation, I actually, thought it was going to be a little easier to prepare this lecture. I would try to offer some inputs and some provocative thoughts on a very slippery issue, which in some parts will also border with political science. This is something I normally don't do, but in this case, I think the borders between the disciplines are a little bit blurred. But having said that, I will share my screen and get you through the subject with the help of a PowerPoint presentation. Now, here you can see the structure of the presentation, the topics I would like to mention and hopefully then discuss with you, hoping to be provocative enough to provoke some thoughts and questions. First of all, well, we can start with the definition of territorial conflicts. Why territorial conflicts and not sovereignty, for example, or secession, etc., etc. Then we will move to secession and to the challenges it represents for constitutionalism. An important part is also to try to link the understanding of territory with the procedures that are applied in these territorial conflicts. Then we will look at the various instruments. This is much more legal and positivistic sort of part of the presentation, on looking at what instruments are indeed being used to solve or at least proceduralize such conflicts. Also looking at the referendum as the main of those elements, but by far not the only one. Then we will conclude by proposing some views on constitutionalism as a whole, on the way constitutionalism is evolving through the lens of these territorial conflicts, and also about the role of law more in detail. Feel free to interrupt me also during the presentation if something is not clear or if you have immediate reactions. I'm really happy to not speak all the time just myself, also in order to bring some more dynamic into the presentation. All right, let me start with the working definition of the term territorial conflicts. Why do I mention territorial conflicts instead of other terms? Territorial conflicts are more generally disputes over the status of a territory. When the status of a subnational entity, so we're not speaking of states, but we are speaking of subnational entities, sometimes also just administrative subnational entities such as municipalities, when the legal status of this territory is politically disputed. So I'm not going to speak about legally disputed territories in international law, or frozen conflicts like leftovers of conflicts, especially in the former Soviet space, but where there are claims that are intimately politically at the beginning over the status of a territory. This, of course, include secession, but also other forms of disputes, such as the internal change of borders, when, for example, the establishment of a new entity is claimed, or when municipalities are moved from one entity to another entity, or just the status of an existing entity that claims to be enhanced, such as asking for more autonomy for a given entity. So grouping all them together, I came up with the term territorial conflicts, trying to include everything. When it comes to the internal changes, especially internal changes of borders, we normally find some detailed norms, more or less detailed norms in national constitutions, like, for example, Article 29 of the German Basic Law. In Italy also there is a provision on that. They are normally not frequently used, but they are there. At least as a procedural framework to channel such potential changes. Much less regulated is instead the issue of secession. When it comes to really to finding a discipline on how subnational entities can secede from the state they currently belong to. It's only 6 constitutions in the world that explicitly admit secession and provide for some procedure to achieve it. And these countries are Ethiopia, surprisingly, people wouldn't say that, but France for New Caledonia. So it is a process towards independence. Liechtenstein, just for municipalities, of course. St. Kitts and Nevis, which is for splitting the 2 islands. Uzbekistan for Karapakalstan, which is a on paper autonomous entity, which even has the right to self-determination, but of course it's just there on paper. And Moldova for Gagauzia, in the case of Moldova deciding to join Romania. So in that case, Gagauzia will have the right to decide over its own political future. Then there were past examples like the Constitution of the Soviet Union, 77, Yugoslavia, more recently Serbia and Montenegro in 2003, which didn't last for long, etc. We have 25 constitutions that explicitly prohibit the secession, and 32 constitutions that implicitly prohibit it by having clauses stating the principle of unity and integrity of the territory of the state, etc. This means, and that's a study by Who's that? Versteeg and, help me, Giuseppe. Versteeg and somebody else. I don't remember now the name. They have counted all these constitutions. It means that exactly. Thank you. That 67% of the constitutions do not mention secession at all, neither allowing for it nor prohibiting it. Despite the fact that constitutions are mostly silent, and when they say something, they normally say it is simply not possible, secession happens, obviously, as we all know. Since 1990, so in the last constitutional wave, 29 states have been established. When we take into account the past 50 years, it's 60 states. And since World War II, it's not less than 129. Taking all these cases into account, we have about 1/3 of all of these countries having born out of unlawful secession. And if we consider decolonialization processes, which of course are a little different, but initially, of course, it was also not allowed for these territories to secede from the colonial state. We have 2/3 of the countries, the existing countries in the world, that have been established by means of an illegal process of secession. So it means that legal prohibitions do not stop the process at all. Now, what is then the problem? We have provisions that are, when they exist, quite ineffective in banning or at least limiting processes of that kind. And this is where constitutionalism jumps in. Constitutionalism means, after all, the need to put certain processes that normally would happen outside of the realm of law within the framework of a legal procedure. This is something that has always happened in history, at least since constitutionalism exists, and has happened in a number of other fields, other than secession, I mean, such as judicial review of legislation, for example, or constitutional amendments. You know, the first constitutions didn't have it's certainly not a sophisticated amendment procedure. The form of government, usually in the constitutions of the 19th century, that was very rudimental. And then, of course, the process of rationalization has come up with a number of detailed rules. So this is the new one of the areas when constitutionalism is now playing a role, when we see that there is an increasing trend towards the establishment of legal rules in an area that until recently was completely left to the political realm. As I said, constitutional provisions are very rare in this area. There are a few more rules that derive from judicial rulings, notably, of course, the mother of all of these rulings being the reference on the secession of Quebec by the Canadian Supreme Court. I don't need to tell more in this audience about that reference. The Constitutional Tribunal of Spain also had the opportunity to issue a couple of interesting rulings in this regard. The Italian Constitutional Court also took a stand. We can also consider the UK Supreme Court in the case Miller when it comes to procedures on how to exit the European Union, etc. And then we find some legislation, not much, and when we have legislation, it is really ad hoc. So it is not a structural piece of legislation, but is something that has been adopted in order to regulate a problem that was burning at the time. So we have, for example, the case of the Scotland Referendum Act that was adopted in order to allow for the referendum in Scotland on independence 2014. We have the law in Montenegro regulating the procedure for splitting the Union of Serbia and Montenegro. We have the French laws on New Caledonia. And then we also have some rules on internal secession, like in the case of Ethiopia, of the establishment of the canton Jura in Switzerland. I will come back to that later on, etc. Of course, we also have a bunch of illegal legislation, which is relevant, but yeah, it doesn't amount to a legal procedure proper. But there are many laws that have been adopted by subnational bodies in particular, regulating a secession process that were, however, illegal, either internationally or domestically. There was a case in Kurdistan when the referendum was held in 2017. The more known case of Catalonia, also 2017. The very process of independence of Kosovo, which was, as a matter of fact, illegal back then and has been successfully recognized afterwards. Crimea, of course, we also have the whole provision of the whole opinion of the Venice Commission, affirming that it was fully illegal under international law, but according to Russian constitutional law, it was perfectly fine. Many proposals for secession by Republika Srpska in Bosnia and Herzegovina, etc. Well, so we have a bunch of rules here and there with a different legal status, but we have no systematic rules on that. And constitutionalism is about to work on it and trying to seize some areas and bring them in the realm of law. What type of procedures? Well, as I was saying in the outset, the procedure depends a lot on the perception of the territory. In other words, depending on how a territory is perceived, both a nation state and a subnational entity, this also very much influences the procedures that are put in place or are proposed to solve a territorial conflict. So we have at least three main approaches. At least this is how I see it, and will be happy to discuss with you further. The perception of the territory as being the property of the ruler, right? In this case, it's pretty obvious. So when the ruler decides that the territory needs to be autonomous, then there is a top-down, often violent process of secession, and if this process is successful, then it works. If not, it then remains in the territory of the state, normally after a bloodshed. When it becomes, I mean, the understanding of the territory is that of the property of the people of that state, then normally we have a sort of a plebiscitary approach. And this explains why in recent times all these sort of processes are linked to a referendum. So it seems that in the time of democracy or democratic understanding or misunderstanding, the populist misunderstanding sometimes, a referendum is considered to be inevitable. It's considered to be the instrument to make decisions over a territorial conflict. So it has evolved, I would say, out of a positive understanding of territory as the property of the people, but then it is easy to degenerate into a plebiscitary populistic element. Only when the territory is not seen in terms of property, but is seen as something regulated by law, irrespective of who is inhabiting the territory, then we see some more sophisticated procedures on top of referendums, or at least making referendums a little bit more sophisticated than just yes or no. And this misunderstanding that is normally to be observed in most of the understanding of territories depends on what I would call the law of ownership. So if there is a sort of a ethnic approach to the territory, this territory is the property of that particular group. You can have it at the level of the nation state, you can have it at the level of the nation region. And in that case, you have normally the trend towards more plebiscitary elements, like a referendum, the majority decides, the majority coinciding with the titular group that is supposed to be owning that territory. When you have a more civic approach, or the autonomy of the entity and not for a specific ethnic group, then you tend to have more nuanced and sophisticated procedures. This is, sort of a classification that I have made, and I would be happy to discuss with you. For sure, a lot of that depends on the Soviet legacy. The Soviet legacy has deeply influenced the way territories are seen. In the understanding of the Soviet federalism, that was an ethnic federalism. Georgia was the state of Georgians, and Azerbaijan of the Azeri, and so on and so forth. And then it also created, in a way, the political borders that, at the time of the dissolution, just could become national states, with all the problems that went with it. And we all know what I mean by that. There have been conflicts for the last 30 years, and now we are also living through a very bloody one. So this idea of ownership and of ethnic property of a territory, rather than a more civic approach, determines very much the approach and the procedures that are proposed to solve territorial conflicts. Normally, the push for secession is proportional to the ethnic understanding of the region. If a region has an ethnic understanding, has the idea of being the property of one group, being it ethnic, linguistic, religious, what have you, then it is more likely that the pushes for secession become visible. And when it's more civic, then normally also the push for secessions is much more limited. I have put here 3 prophecies because then, of course, it depends, and there are different readings of the issue. One is by Robert Friedlander back in 1981, who says exactly that. So normally, as autonomy is considered to be something ethnic or for a group, and as a sort of a plan B when you cannot achieve full statehood, then autonomy is, as you see here, the quote, is most often only reluctantly granted and usually ungratefully received. It means that the state is not happy to give autonomy, and the territory / the titular ethnic group which is a majority in that territory, is not happy to receive it because they had actually wanted something more, meaning full statehood. Michael Keating in 2002 has actually proposed a different reading, a completely opposite reading. Said, yes, it might be true that the ethnic autonomies are more likely to push for secession, but if there are good incentives for participation, multi-level governance, especially he was referring that to the European Union, so being convenient of being a region rather than a state, then of course the incentives for claiming secession are not there, and autonomy within the borders of the state are more popular. So if regions have a voice, then they do not need to look for exit. But I would say just, well, it depends, of course, and each case is different, but we should never forget the prophecy of Bertolt Brecht, who used to say that an idea is not responsible for the people who believe in it. He was mentioning that notably in regard to communism, but it also applies to the idea of autonomy. Autonomy is neither good nor bad. It very much depends on what people make out of it. All right. So after this general framework, let us look a little bit at the procedures that are to be found in a comparative observation. So as I said, there is a general trend of proceduralizing secession claims. And after 1989, when democracy has been discovered or rediscovered, then referendum is considered to be a must. The last secession that took place without a referendum was the split of Czechoslovakia in 1992, because the elites basically agreed. But also it seems that there were polls saying that the population kind of supported that, at least in part. One could say, well, in Kosovo in 2008, there was also no referendum. That's true. That was a unilateral declaration of independence. But there has been a referendum back in the 90s at the time of Serbian oppression that was overwhelmingly in favor of statehood. And actually the Declaration of Independence also makes reference to that as a sort of a legal continuum from that referendum. But apart from that, referendum is always there. What is the problem? That democracy can easily, especially through referendum, move into populism. I mean, Giuseppe Martinico is a great expert on that, has written extensively. But if you move, so if democracy moves to populism, then normally a referendum becomes rather a plebiscite, and this is problematic. Sometimes this can also happen due to external or geopolitical factors, such as the case of Crimea, pretty obvious, or Gagauzia that held a referendum in 2014. The various referenda in different former Soviet places, Nagorno-Karabakh, Donbass also recently, and other experiences that are less known, Gibraltar, the Falkland Islands, Somaliland, obviously kept hostage of geopolitical considerations and not necessarily based on internal domestic factors. So the referendum is always there. The problem is whether the referendum is sufficient or not to regulate the territorial conflict. Of course, there are always problems. So whatever solution you find, you have a different problem. It's like taking a pill that probably solves a problem, but gives you another problem. Then you have to take another pill to solve the problem originated by the first pill. So first of all, referendum as such doesn't mean much to us as lawyers, right? It depends on a number of elements of this referendum. So, for example, a quorum or no quorum. If we have no quorum, then the problem is that a minority decides. Yeah? And this is clearly problematic if you want to ascertain the will of the majority. Maybe some of you is familiar with an old ruling by the Bavarian Constitutional Court back in 1998 on the suppression of the Bavarian Senate. And it said, no, look, it cannot be done by a referendum without quorum, because then it can happen that a small minority decides over a constitutional issue. And then it even dictated a reasonable quorum, which was considered back in that case to be of 25% of turnout. So, you know, the problem of no quorum is obviously that. But if you have a quorum, then of course you penalize the promoters of the initiative, because there is a degree of abstention which is naturally there. And this is an argument that was brought forward even by the Venice Commission on its code. I think it's called Code of Conduct with regard to referendum 2006. I encourage you to read it. I find it a bit disappointing, but certainly this element is there. It's a problem. So you have a quorum or not, and you necessarily have a problem in any case. So instead of self-determination, instead of claiming for secession, etc., now the political discourse is normally that of the right to decide. But whoever claims for the right to decide actually means self-determination, pro-secession, and no quorum, of course, because it has to do with the ethnic reading of the territory that I was mentioning before. As a matter of fact, and you can see it in one way or the other, but you normally always have a problem with a referendum. The problem is to split a society. Normally along this line, you tend to have 50-50 of the population, a bit more, a bit less, but it's a decision that it's too sophisticated, too complex to be made by a simple majority. You remember the case of Quebec in 1995, 50.6% against secession means that actually 49.4 were in favor. So what have you there? You have a split society. The same or very similar in Scotland, also in Catalonia. It seems also that the population is more or less 50-50. Or you have problems with structural minorities in certain territories. We all know, for example, that the Brexit referendum had a different outcome in Scotland and Northern Ireland, where there was a clear majority against the leave, but then it was the English vote that imposed something on structural minorities. So the marginalization of structural minorities is a problem. Okay, so the fact is referendum needs to be integrated by something else. And what is this something else? Well, we have again here the landmark decision of the Canadian Supreme Court that says, yes, secession is possible if there are a number of prerequisites. One is the clear majority, which means a referendum, and also a referendum with higher thresholds. But also other underlying constitutional principles need to be respected: federalism, democracy, constitutionalism, and the rule of law, and the respect for minorities. So to try to avoid what I have just mentioned before, the marginalization of structural minorities. Then we know the Parliament has adopted the Clarity Act in 2000, laying down some principles, including the requirement of an amendment to the Canadian Constitution, which de facto makes it extremely difficult procedurally for one province to secede. Be it as it may, but you always have a certain degree of politicization of the issue. Like Scotland, for example, a referendum was allowed in 2014 when London was pretty sure that there was not going to be a majority for secession. Now it has been requested again, and of course, being it a little much more uncertain the outcome, then London decides that there won't be a referendum. So very political issue. The question in Spain and Catalonia, there is a formalistic response by the Madrid government and the Constitutional Tribunal saying, well, a territorial referendum is not possible, but you just can modify the constitution. This is not impossible. Well, it is not impossible legally, but practically, politically, this is an answer in a way. But even in Quebec, the Quebec legislature has imposed the mirror law in response to the Clarity Act, stating, again, very politically, no other parliament or government may impose constraint on the democratic will of the Quebec people to determine its own future. Again, saying the referendum, in the end, should it happen, will prevail. Other political issues, of course, are, who has the right to vote? What is the constituency like? Are the territorial delimitations and the electoral laws relevant to the outcome of a referendum? Of course they are. Again, the different constituency in the Scotland referendum, where also foreigners living in Scotland could vote, and people with 16, etc., versus the Brexit referendum, where the constituency was more reduced and the outcome was different. Also, the electoral law plays a role. According to polls, in Catalonia, there is no majority of the population in favor of the constitution. Is something between 45 and 48%, so a very sizable minority, but not the majority. But the Catalan parliament has a majority of independentists because of the way the electoral law is constructed. So it is political in the end. But what happens? So this is the final part, and we look at the legal instruments. You can have referenda that are entrenched, so not a simple majority decision, but, for example, a quorum. You can have a quorum for the turnout and for the approval, like in Montenegro, 50% of turnout was required and 55% in favor, and that was met. In Italy, it's not a very popular subject, but the constitution provides for a procedure for establishing new regions. There is a referendum that is obligatory and is binding, but the proposal can only come from a number of municipalities representing 1/3 of the affected populations, and then the approval of the referendum must be by the majority of the voters and not only of the votes. So again, an entrenchment in terms of the quorum. Another technique is to have more referenda, more than just one, like the case of New Caledonia, 3 referenda in 6 years, all with the outcome of no to independence for the time being, or the time limitation before a new referendum. This is always an issue. When is the time when we take the picture of the will of the people? Now in Scotland, again, after Brexit, the situation has changed and there is the claim for having a new referendum, and then London, well, just says no because the issue has been settled back in 2014. How long does a result last? The Good Friday Agreement provides for a time for 7 years between referenda on status of Northern Ireland, and we can find many different time frameworks in the rules on constitutional amendments in comparative law. The very interesting case is that of the canton Jura in Switzerland, which was formed in the 70s. The procedure there was very fascinating. So there has been a constitutional amendment to the cantonal constitution of Bern, Basel, that was adopted and then ratified by referendum. And this constitutional amendment made a regional referendum possible on the district of the region of Jura to become or not to become a canton, but also then referenda at the district and at the municipal level for the case a district or a municipality would have voted in a different way as the majority of the region of the new canton. So if the canton had, so like the canton has voted in fact for creating a new canton, but if a municipality or a district was against, then they could have requested a referendum to remain with the old canton. So a very interesting way of proceduralizing that. And then we also have at the EU level several examples of new referenda after renegotiating certain procedures. Ireland did it for the treaties of Nice and Lisbon, initially rejected, then negotiations, and then a new referendum that was adopted. Denmark did it for the Treaty of Maastricht, and so on. And then a very important option, the multi-option referendum. So you don't only have yes or no, status quo, independence, but you have also a third option or more options on the ballot. The issue was very relevant in Scotland when initially the options were three: status quo, independence, or more autonomy, devolution max. And then it was taken out because the London government, being pretty sure to win the referendum, said, okay, you decide, but then if you decide, you remain with the status quo. But then the Scotland Act 2016 actually did exactly what devolution max was proposing. The same happened with the Brexit. The agreement with the EU was reached, but then it was predominantly an issue internal in the Conservative Party, where people like Boris Johnson wanted to push the responsibility on David Cameron and said, okay, we only have to vote on stay or leave, but not for this new treaty with the European Union. But it's an important option. Then there are entrenchments that go beyond referenda. I need to slowly come to a conclusion, right? How much time do I still have? Do I have 5 minutes? Is that enough? Yeah. So entrenchments not of the referendum, but beyond the referendum. So it can be requested, for example, by a qualified majority of parliament. This is the case of Ethiopia, or Italy for the municipalities, the procedure I was referring to before. The referendum to be followed by a law. Again, in Italy, a constitutional law for establishing new regions, an ordinary law for municipalities that move from one region to another. And you also need the consent of the region in case a municipality wants to move to a special region. Then there is an issue with regard to the involvement of courts. So this happens either as a matter of law. In several legal systems, we find the involvement of the Constitutional Court in the constitutional amending procedure, either preventive or successive or both. Ukraine, Chile, Costa Rica, Moldova, etc., they have it, and as a status, a change status is obviously also implying a constitutional amendment, then there is a formal involvement of the court, or the courts get involved as a matter of fact, because these issues are likely to end up in constitutional courts. Again, Canada, Italy, Germany, and the cases I mentioned, including Iraq and many others. Another entrenchment is to go via obligatory elections, either instead of referendum. Again, in Catalonia, the independentist parties have said, okay, we are not allowed to hold a referendum, then we will have a sort of a political referendum by means of elections. Same thing is going to happen in Scotland. Or you have elections on top of referendum. There are especially the countries that provide for a procedure of total constitutional revision, Spain, Bulgaria, Switzerland, etc. You can have a referendum, an obligatory referendum for the constitution, an obligatory referendum and obligatory elections after the referendum itself for amending the constitution. Or then you can have the referendum deciding on the principle, yes or no, and then a formal involvement of the parliament with regard to a lot of details that can also amount to substantial issues. A bad example again was Brexit, because then the people didn't realize that there was the need for detailed negotiations on a number of things. A good example, I can mention that of New Zealand, for example, that holds a referendum on legalization of drugs in 2020. And it was just about the idea itself. And then should the people have adopted it, it didn't pass, then it was up to the parliament to decide on a number of important issues, such as the distinction between legalization or decriminalization, etc. So you can also have a referendum saying, okay, secession, yes, but then how and under which terms that should be decided by parliament. And then, of course, there is the big deal of participatory democracy. Constitutional change is required always when it comes to solving territorial conflicts. You have had a couple of lectures already in this series of seminars, so I don't delve into that. But the constitutional amending process is becoming increasingly participatory as a means to provide it with legitimacy. So we have many cases like Iceland, you had a lecture, Chile, the constitutional crowdsourcing, etc., etc., but many more cases actually. I would love to mention, but I don't think I have the time, the case of the South Tyrolean so-called Autonomy Convention, which had actually a majority of people proposing or being in favor of secession. But that was, again, a participatory instrument that made proposals. And the very idea of participatory democracy is to elaborate proposals outside of the formal amending procedures, and then the bodies in charge, being parliament or being referenda, etc., can decide after the decision was kind of prepared. So this is a whole important set of instruments, but you had enough presentations on that. And let me conclude. Are we living in an era where constitutionalism is blossoming, and therefore also areas such as territorial conflicts and notably secession are to be subject to legal procedures? Or is constitutionalism in the current time kind of sinking into populism, becoming populism? The territorial conflicts are an important litmus test for that. And especially the idea of the referendum as an instrument of participation or of populism is very key on that. There is no question that we have to address the problem of oversimplification and of populism. Legally, there is a natural tendency of constitutionalism to occupy with legal rules area that were previously regulated by the rule of politics or by the rule of force, and include them into the rule of law. This is very, very important. And as I said, this also happened in the past in other areas, such as the form of government, the constitutional amending process, the judicial review, etc. And the question is now, I think, very relevant, especially in two areas that are still predominantly outside of the scope of legal procedures. One is territorial conflicts, as I said. Another one is the emergency provisions in constitutions. We have just seen it with the pandemic, and we will see it with the global climate emergency, etc. We live in a permanent state of crisis. Are constitutions equipped for that or not? So I would just warn against the praise of political constitutionalism, which is what is normally done. Many people say, oh, the British constitution is fantastic because it's a political constitution and they allowed Scotland to hold a referendum. But political constitution is exactly the opposite of the trend of modern constitutionalism that tries to provide for legal rules. And the role of the law is to establish a rule of the law, because if it doesn't happen like this, you can have a beautiful aquarium like this, but you just heat it up and it becomes a fish soup in a second. So really be careful, and purely political constitutionalism is not going to be the solution, but in my view, rather part of the problem. I stop here and thank you very much for your attention. And I look forward to the discussion, hoping that you still have some strength for it. Thank you so much.